Please be seated. We'll hear argument in 21-1063, Henry Kappemeyer.
May it please the court, Mr. Sutton will present argument for the relators. Relators have reserved 5 minutes for rebuttal.
Thank you, Mr. Chief Justice, and may it please the court. The question before us today is, if a homeowner sues an entity which claims to represent all the homeowners in a subdivision, and the suit is about that association or that corporation's own actions, does the homeowner also have to sue all of the members or shareholders of that corporation or entity? In this case, it is somewhat surprising that a homeowners association, a claimed homeowners association, over 700 persons, when sued for something it did, then told its homeowners, in essence, we want them to sue all of you too for what we just did. What I will argue today is that this court's jurisprudence, beginning in 1977, makes the jurisprudence clear and coherent on this question. But what happened is when cases shifted into the homeowners association context, things became muddled. In essence, ignore Rule 39 at your peril. Rule 39 renders the jurisprudence coherent. And so I'd like to cover two areas today which generally track Rule 39. First, is there an entity which purports to represent the homeowners? I've given you as an exhibit permutations on this question, which is some subdivisions have no mandatory homeowners associations. Some do have a mandatory homeowners association, and some have a purely voluntary homeowners association. In all the cases, these are entities. And so this question about whether there's an entity goes to the question under Rule 39A1. Can there be complete relief among the parties or between the parties? And relatedly, will there be prejudice to a party if there is not joinder under the Declaratory Judgment Act? The second question, the second issue I'll cover today is, does anyone besides the entity claim an interest under Rule 39B2? And this is the point at which several of the cases after 1977 and also after 2004 in this court's decision in Simpson and Brooks against North Glen, they go astray and they get the answer wrong. And the essence of it is they forget to apply Rule 39. Okay, first, Rule 39's requirement of complete relief, the first of two alternatives for requiring joinder. So if someone brings a motion to abate pending joinder, they can either show the first prong, one that complete relief can't be afforded without a party, or if they can't show that, they can go to the second alternative, which is that joinder, I'm sorry, I'm losing track of this, that someone claims an interest in the subject matter of the litigation. Okay,
what do we do with the apparent inconsistency between the Declaratory Judgment Act rule for mandatory parties and then the Rule of Civil Procedure?
There is no inconsistency. This court said in the Clear Lake case, which is, I should give you the citation because we didn't have it in our briefs. This was a case that was relied on in 2004 in the Brooks case and the Simpson case. Clear Lake is 549 Southwest 2nd, 385. And so in 1977, this court said, these are essentially the same thing, and you must satisfy Rule 39 in a declaratory judgment case. And so the court said, in essence, these are kissing cousins. Both have to be satisfied in a declaratory judgment case. In the case we're talking about today, the Kappemeyers brought suit based on something only the HOA's board of directors did. The HOA board recorded a new set of restrictive covenants. And the Kapppemeyers claim, very similar to the claim in the this court's Simpson case in 2004, said, in essence, these restrictions aren't valid, but they pled that more carefully than happened in Simpson. In Simpson, back in 2004, Simpson pled the restrictions need to be declared void, suggesting that everyone would be affected. I think the Kapppemeyers took the lesson from some later cases that you probably ought to plead this more carefully.
So you think the pleading here is more like the one in Epernay?
The pleading is like the one in Epernay, and there are a number of those cases, like in Ray Corcoran, where the plaintiff was careful to plead relief solely for themselves. One of the cases involves a basketball court, but another of the cases does involve essentially voiding deed restrictions.
And if they don't agree that it's sufficiently narrow, presumably you would want an opportunity to replead.
That's right. And there were cases several years ago where I got this challenge, and I repleaded to make it more narrow, just to avoid any conflicts on this, because I don't need broader relief if I'm trying to protect my rights. And so the Kapppemeyers pled, HOA, whatever these restrictive covenants mean, whether they're valid or not, you can't enforce them against me.
Did the Kapppemeyer's restrictive covenants and conditions contain anything about amendment and how that could be done?
These restrictive covenants, my recollection is, don't have an amendment clause. And so the association is they have a nullification clause. And so the association would be able, because there is an association in this case. It just doesn't happen to have authority over the Kapppemeyers. The association is relying on Chapter 209 of the Property Code, which is a fairly new provision that says, if there is a mandatory association which has any kind of assessment or levy power, then the restrictive covenants can be amended by a 2/3 vote of the owner. And so that, I think, solved the issue here, whether there could be amendment.
But the Kapppemeyers aren't relying on the interpretation of restrictions or covenants that apply equally to others in the Unit 1 of Key Allegro to invalidate the homeowners association's interpretation here. In other words, they're just saying we're not bound by it, but they're not relying on some other set of restrictions or covenants that might apply to to homeowners that are similarly situated to them.
Correct. They are relying solely on the restrictive covenants for Unit 1, which has about 200 homes. Now,
That's about what?
about 200 homes.
Right.
There are 5 sections, and all the restrictive covenants are identical. So for the 700 people, anyone who's been affected like this could bring the same kind of claim that they did, or alternatively could be subject to some kind of claim by the HOA for assessments. What the HOA did with the new restrictions is adopt a new set of identical restrictions for all 5 subdivisions, in essence replacing the ones that had been there for the 5 before. I think the key to understanding the first prong of this case is actually that Arnold versus Addison case from the Dallas Court of Appeals from 2021. This is such an interesting case because I think what it tells us is that we're dealing with a lawsuit against a nonprofit corporation where someone is saying, in essence, you have to pierce the corporate veil and go sue everyone who's a shareholder or a member because they're, quote, as the HOA says in this case, affected by it. Well, that would be as if Apple Computer were sued for a design defect with its phone, and a court said you have to sue every shareholder. It's no different, and that's what the Arnold case actually tells us. So you'll recall that in that case, the homeowner was making the same kind of challenge, actually, that the Kapppemeyers are making. There was a problem in how a board adopted a new set of restrictions. And the homeowner also sued the 5 individual directors. And the court said, you can't get any relief against the individual directors because they were acting as a corporation when they did this. Well, by the same token, you can't get relief against the individual 700 owners in this case. They can't go on their own. No individual owner could go record some new set of restrictions which withdraws the prior set or changes it. Only the board that recorded this, what we assert is an improper and invalid set of restrictions, could go record something new which either corrects it or reflects a judgment by a court that says they're not valid.
That sounds to me like a very sensible rule for mandatory joinder, that you would look to, whether, as between these two parties, there's a judgment that could order the one to do something that would, provide relief to the plaintiff. But I wonder whether that's inconsistent with the rule of civil procedure. The rule of civil procedure seems broader. It seems that it would suck in people of whom that is not true. I mean, people who, as a practical matter, might have their rights impaired or impeded. There could be people in that category that would not be proper defendants in the sense in which we normally think of a defendant as amenable to some order or judgment that's going to redress the injury.
Justice Blacklock, I think that is the single most interesting issue in this case, and that's the reason that I provided the exhibit beforehand, and I want to talk about that now. There are 3 fact patterns mentioned there, and I want to talk about the first one, which is, what about a situation in a subdivision that has 700 people but no entity representing the homeowners? Now, I've had many cases like this, and I've had cases where we challenged a set of deed restrictions as completely invalid. Usually it's because they expired 10 years ago. Now, how do these cases arise? Typically they arise because one homeowner says to another, you can't build that, or you have to stop doing something because the restrictive covenants forbid it. And what we say is, well, no, the restrictive covenants expired 10 years ago, and we want to get the jump on you on attorney's fees. We have to be, for complicated reasons, we have to be first into court to preserve that claim. So we're going to file a DJ against you, Mrs. Smith, next door, who has said we can't do this. And we're going to ask the court to declare what? The deed restrictions expired. Well, we can say for sure that 700 people are affected if a set of restrictive covenants which expired 10 years ago are actually declared to be no longer in force. But that's not the way the case arose. The case arose under the kissing cousin of Rule 39, the DJ Act. There is a live dispute between 2 people, and I filed a suit to get that attorney fee claim, but the essence of the dispute is whether there's a breach of restrictive covenant. And if the court declares that the restrictive covenants expired, that is complete relief between those 2 parties. And under the DJ Act, no other homeowner is prejudiced in being not able to bring the same kind of suit. Now, I want to change up the fact pattern a little bit.
What if another homeowner claimed the interest? So in other words, you're challenging the trial court's requirement that you join all these additional people. But do you concede that if another homeowner decided my interests might be affected here, I want to intervene, would you oppose that? Or do you believe that there's permissive joinder at the very least here?
Permissive joinder, certainly, that person has to basically show jurisdiction under the DJ Act. Well, that person either has to claim a breach of restrictive covenant, which would confer jurisdiction, but under the DJ Act, you have to show there's a live controversy. So if they come into court just saying, oh, I wish the court would say this, but they don't actually have a dispute, there's no jurisdiction. But in HOA cases, as a practical matter, if someone says, I dispute your right to do this, there is a live controversy under the DJ Act. So then in 1977, this court says, well, then you still have to go through the exercise under Rule 39. We know there's jurisdiction, but is joinder mandatory? So there would be permissive joinder. But then, said this court in 1977, that's the Clear Lake case, you must analyze this under Rule 39. And I'll jump ahead, which is to your next point. This is that second prong of Rule 39A. The person seeking joinder, if someone is asking other people to be brought in, has to show, they have the burden to show, that that person does claim an interest. Now, that language is also in the DJ Act. So what you have in essence...
Except it DJ Act says persons who have or claim. Is there a difference between those?
Yes, there is. I think the DJ Act is broader, and if someone has an interest, they must be joined, but under Rule 39, the burden of showing they must be joined falls on the party seeking joinder. And then under Brooks in 2004, they have to actually demonstrate that interest in order for those particular people to be brought in.
I mean, it seems to me here that the HOA could come to court and say, even if we just limit it to Section 1, or even more broad, all of these owners of canal lots have an interest in the outcome here because they're going to have to pay more if the plaintiffs win, right? And so they all have an interest in the outcome here. To me, that is hard to argue that doesn't satisfy the DJ Act's requirement. But it may be that none of those canal lot owners, have in any way expressed that interest or claimed that interest, and therefore you're not satisfying the rules.
39A1 isn't satisfied.
Right.
This court said you have
And
to
so
satisfy.
what result there? You're satisfying the DJ Act requirement, but you're not, that says you must join a person who has an interest.
You said in 1977, your predecessor said, well, you still have to satisfy Rule 39A1.
You gotta
have to
satisfy that.
prove that they have an interest. They
So
claim
if-
an interest.
So then if the HOA comes in here and says, look, there are, I don't remember the numbers, there are 37 canal lot owners here, and 7 of them have sent letters saying, we hereby legally demand that you do not agree with the Kappemeyer's demands here. Because if you do, you're going to negatively affect our interest. Now, have they claimed an interest, those 7?
I have never yet seen, and I don't think in any reported case, there is an HOA that has provided evidence that another homeowner claims an interest, and I don't exactly know what that evidence would be.
So a letter from a canal lot owner saying, we understand that these bay lot owners have demanded that you unamend the restrictions and take this away, and we are here to tell you that we have an interest in this, and we demand that you don't unamend the restrictions.
That satisfies Rule 39A1.
Don't you think that satisfies?
It does.
There would then be 7 of the 37, or whatever the numbers
Yes.
are, that you would have to join.
Yep.
Okay.
Exactly. You come into court, I as a plaintiff do want a good adjudication of the claim. I don't want 7 other people in that HOA to come after me for breach of restrictive covenant, and the reason I don't is because if they sue me first for breach of restrictive covenant, even though I just got a judgment against the HOA, or if I didn't and these people win, they have a mandatory attorney fee claim, but I can't get my fees paid. That's why these DJ cases by homeowners come up, because strategically we have to file first. But we only want relief for ourselves. Now, I suggested another alternative to the HOA or the subdivision that has no HOA. And again, let's say there are 700 people, usually it's less than that for an older subdivision with just restrictive covenants. You know, you can't graze cows and you have to build a house of no more than 2,000 square feet. What if I'm just trying to sell my house and the person who buys it says, look, I'd like to buy it, but I'd give you more money if there were no restrictions so that I could, build a gas station. And so I go into court, and with no real controversy between anyone, I say, court, I want a declaration that these deed restrictions are not wholesale invalid. Well, first, who do I sue? No one has actually threatened me. All I have is a desire to sell my land. Probably at that point, there's no live controversy, but I do, in essence, want a clear title. And we asserted clear title in this case, and there was never an issue whether we could seek relief just for ourselves for quiet title. We were told we'd be dismissed if we didn't join for our DJ claim. But nevertheless, I do have a real problem in that I need to close.
Your time is expiring, Mr. Sutton.
Oh,
Any
I
other
was looking at
questions?
The wrong light.
We'll hear from the real parties.
May it please the court, Mr. Godkin will present argument for the real parties in interest.
Good late morning to all of you. It's a privilege and honor to be here. I want to apologize in advance if I have to sip the water. The live capital music of the world and the allergy capital of the world in Austin has affected me. I'd like to address why we're here. I disagree with all due respect to Mr. Sutton. The question before the court is a very simple one. Did the trial court abuse her discretion in ordering joinder in this case? Meaning, did she just ignore the rules, the law? Did she fail to follow any of the principles, guiding principles set out by this court and other courts? The answer is a resounding no. Judge Bauer held a hearing. It was an evidentiary hearing where I presented the only witness. That witness was Ms. Lynn Powers, who is the board president. She testified without any contradictory evidence presented by plaintiff's counsel at the hearing that this would, in fact, impact all remaining owners in the community.
Why do we reach that issue under 39A2 if there's no one else claiming an interest?
I, with all due respect, Your Honor, disagree with the interpretation of how Mr. Sutton is presenting Texas Rules of Civil Procedure 39.
Well, it seems like we followed that interpretation in the Crawford case, where we said that if you don't have to join adjacent landowners in an oil and gas context, and it seems like the facts here are pretty similar, and so I'm wondering why this isn't a case where there's no joinder under Crawford.
Yes, sir. Crawford, I believe, is distinguishable in the fact that I believe in that scenario they were not parties to this contract. All of the owners in this community are subject to the restrictions made the basis of this lawsuit. I do believe that the issue of are the remaining owners going to be impacted?
It seems like in the Crawford case, there was actually more of a risk of inconsistent obligations because the other people who were being paid under the unit were actually got more royalties than the party to the case contended they were entitled to. So there would have been inconsistent obligations on the defendant. It might have had to pay twice, and we said that doesn't matter because none of the other people who had to be paid had come forward and claimed an interest.
Yes, Your Honor, but again, we're talking about in that particular case, the way I understand the facts of the case, was that we're talking about folks that were not actually part of that contract. In this case, all of the owners, the remaining 700 owners.
Well, they were all part of a unit agreement, I think. Isn't that a contract?
Yes, sir, it is, but they were also neighboring parties. In this case, what I think is critical is that this court has already decided, and referencing Dahl and the Brooks versus North Glen case, that this is, as well as going back 35 years to the Inwood HOA versus Harris case, these are fundamental property rights that are being affected by this declaratory judgment. And in fact, if you look at the Inwood case, the case law that is set out, or the language set out in the opinion of the Supreme Court, talks about the fact that the pro rata share of what is being paid for assessments and making sure that everyone is paying their pro rata share, that is a fundamental property right. The very issue in this particular case that Mr. Sutton's...
So is a payment on an oil and gas lease.
Yes, Your Honor, I understand. But Judge Bauer, in her discretion, looked at all of this. Judge Bauer looked at the evidence presented, the briefing, the arguments of counsel, and she determined on her discretion that the joinder was appropriate under the facts and circumstances of this particular case.
But if there's zero evidence, and I know you disagree with this, but if there is zero evidence in the record that any person claims an interest relating to the subject of this action, then wouldn't the trial judge have abused her discretion by requiring joinder under A2?
I think if you were, it's a very good question, Your Honor. I think if you were to look at failed to look at the circumstances in the prior case law set out, including the case law and coming from the Supreme Court and the Inwood matter, that has already established these are fundamental property rights owned by the remaining owners.
But they haven't claimed them. That's his argument. I'm not.
I understand.
So it's your position that claim means something different? The mere fact that they have them is sufficient? There's no doubt especially the canal lot owners have an interest here, a valuable property interest, presumably. I mean, I'm not disagreeing with your position there. But did you have some burden to show that one or more of them claimed that interest?
I have not seen a single case cited that discusses in the HOA context that we would actually have to present evidence from other remaining owners that we believe we have an interest that is being claimed here when it's already been set out as a matter of law for 35 plus years by the Supreme Court that interest already exists. So really what would be asked of us as a homeowners association would essentially be this. We would have to go and essentially seek from the community do you claim an interest, yes or no? And if you claim yes, by the way, you're going to be brought into a lawsuit. From a practical standpoint, Your Honor, that would make it almost impossible to govern.
So that what you just focused on, that's a fundamental difference, isn't there? That a person petitioning an intervention, asserting that they have an interest and requesting mandatory joinder is different.
Yes, ma'am.
Than a person who is sued and being directed to be hailed into court.
Correct.
Maybe with no intent of wanting to be there or any assertion of a claim. Could the fact that 39.2 talks about claiming an interest be addressing that difference?
That's a very good question, Your Honor, and I believe the answer is from again, when you look at the case law and what has already been determined as a fundamental property interest and the right of those to be protecting that interest to be brought into the lawsuit, I think it is different. I mean, one of the things that was addressed in the briefing is somehow the association's counsel, or association through its counsel, is representing all of the property owners. I don't represent Mr. and Mrs. Jones and their fundamental property interest. That is not my job as the association's counsel.
So if you were representing Apple Computer, you wouldn't be representing the interests of the shareholders?
If I were representing, I would think it would depend on honestly the context of the case. I think it would
assume it's not a shareholder derivative case.
Okay.
That it's just Apple Computer is suing somebody for failing to pay on a contract.
I'm representing Apple Computer, the entity.
Right.
I'm not representing me.
Nobody would come into court and say, well, I've got a fundamental property interest in Apple Computer because here's my share of stock. And whoever is suing Apple to collect on the contract, you've got to bring in all the shareholders.
I think that's a different situation because in that particular case, if I'm suing on a contract representing Apple Computer, I'm suing on behalf of Apple Computer. There is a fundamental benefit to the shareholders if I'm ultimately successful in recovering under that breach of contract lawsuit.
But the shareholders have an interest that may be impaired or impeded, so do we need to join them?
I think, no, sir.
You're not representing them.
I'm representing a company.
Right. But the shareholders have an interest that may be impaired or impeded, and that seems to be your position on all that's required.
I think what is unique and separate here is this. In the Apple Computer context, for example, I'm representing Apple Computer in a $100 million breach of contract lawsuit with a chip maker. Is there a benefit if I win to the shareholders? Absolutely. Are they detrimentally impacted if I don't win? Absolutely. But again, it is a fall down by being a shareholder. This is a different situation. 35 years, this court has said, these are fundamental property rights that are being impacted when someone seeks a declaratory judgment, seeking a declaration that the governing rules no longer apply. This impacts everything. You got to remember, Your Honor, where this comes from. These were from 1960. There was
Well, and
racially.
Before that, they're from the federal rules, which have a parallel provision in Rule 19. And so I started doing some looking about what do the federal courts do with this, and you may have looked at that as well. But it does seem that federal courts note that you can frame declarations to avoid joinder problems in general, and then more specifically, the Fifth Circuit has held a couple of times that if you've got co-tenants in the same interest in land, and you're only seeking to adjudicate your own interest, the other co-tenants need not be joined. So that's a fundamental property interest, but why is that wrong?
I think under, well, could you clarify your question on that when you say why is that wrong? What specifically are you?
Well, the Fifth Circuit says you don't have to join your co-tenants if you're suing to establish what your interest in the land is.
Mm-hmm. Well, because in that particular case, I would assume that you have a co-tenant that is representing your interest. It's a co-tenant. In this case, again, Mr. and Mrs. Jones, they're not part of this. They're not, their fundamental property interest is not being represented.
In those cases, they were only seeking to adjudicate their own interest and had framed the decree narrowly to avoid adjudicating the interest of the co-tenants. But it seems like that's inconsistent with the idea that once there's a fundamental property interest, you got to join everybody.
Well, Your Honor, I think, again, when Judge Bauer looked at the evidence in the case and the briefing and the arguments of counsel, and her discretion felt that this was appropriate ruling, and joinder is seldom overturned, I think every judge, when faced with situations, is going to look at each particular situation.
You don't think it necessarily would have been an abuse of discretion if she had gone the other way?
I would have been disappointed. Would I have thought it was abuse of discretion? Probably not, no.
So if you know, your friend on the other side, instead of wanting to get a jump for attorney's fees, waited for you to enforce, and then as a defense to the enforcement says,
yes,
no, the governing documents are invalid, they have no claim over me, et cetera, would they have had to try to get 700 people in, or would you just say, well, no, that's a different procedure?
That is a very, very, very good question, and it brings up the second part of Texas Rules of Procedure 39A2II. It, by not allowing for joinder, it opens up the association to a multiplicity of suits. And that was addressed specifically in Brooks versus North Glen by the Texas Supreme Court. In that particular case, a homeowners association did not seek an abatement. And the court said, we appreciate the risk that unless each homeowner is joined in one suit, North Glen may be subject to inconsistent judgments. But it failed to bring up the abatement at the trial court level.
But I'm saying if you started the suit instead of
right.
Kappemeyer.
And under that circumstance, our firm represents a litany of homeowner associations. That's exactly what I would expect. Every time a homeowners association would go to an enforcement action, what you're going to get back is a counterclaim saying, but the governing, the declarations were passed improperly or what have you. And so that's what you're going to get. From a policy standpoint, it will actually encourage exactly what Texas Rule of Civil Procedure 39 says needs to be discouraged.
And so in that situation, when that happens and there's a defense that's a counterclaim that says the declarations are invalid, are you typically successful in getting those dismissed if they don't join all of the other homeowners?
I will tell you, that's a very good question as well. I will tell you, having done this a very long time, what we call the Dahl motion is rarely used. It is something that and again, respectfully disagreeing with the position set out in the briefing by Mr. Sutton, it is not something that is typically used as a sword. It is a very unique circumstance, like in this particular case. But
your position is it could be successful.
It could be, absolutely.
In every case.
And as in certain circumstances, it probably would. I mean, what you have here, and what you typically have, is a rogue owner, here one of 700, that waited 3 years to file a lawsuit after the amendment. And in doing so, it's going to negatively impact the overall community if he is in fact successful.
Well,
Just-
that's the part I'm missing, because it's not going to bind, the judgment in this case won't bind Mr. and Mrs. Jones.
Right, because of the res
So it's only
judicata
going to
issue,
adversely
yes.
affect you.
Right, so
Because
this
you
is,
might have to pay the Kapmeyers, or take the responsibility yourself, or enforce it differently, however it comes out. And the question is not whether you can join them. Surely you could join them all if you wanted to. The question is whether they have to join them.
right.
And why should they have to if you don't want to, and the judgment is not going to bind any of them?
For the Texas Rule of Civil Procedure, irrespective of getting into the issue of do we have to prove that people want to be joined, Texas Rule of Civil Procedure 39A2II says it opens up an existing party, here the homeowners association, to the potential for inconsistent, a multiplicity of suits and inconsistent judgments.
Consistent obligations by reason of his claimed interest. Right, so the threat of inconsistent obligations has to arise from the claimed interest. So we're back with there being no claimed interest by the prospective targets of the joinder.
Right. In Brooks, again, Brooks versus Northland addressed this very issue. And it talked about how the Supreme Court on its own said this. We appreciate the risk of multiple and inconsistent judgments. We have some homeowner associations we represent that actually are in 2 different counties. I mean, and of those 2 counties, you have a litany of judges. However, a fact finder finds in one court, in one county, may be consistently different than what's done in another. How would one expect a homeowners association to govern under that circumstance? You're going to have islands where this particular property had a ruling in their favor, and they're not subject to the governing documents that they signed up for when they moved into the community because of what I truly believe would be a bad ruling. How is that, again, affecting the fundamental property interests of the others? When you look at Inwood, that says one of the things is a fundamental property right of all owners in a homeowners association is to make sure that people are paying their pro rata share. If Mr. Kappemeyer is successful in his lawsuit, someone will be paying his assessments.
I don't understand that, because if I were that someone, I would say, you lost the lawsuit, you pay it.
If Mr. Kappemeyer is successful in his case,
Yeah.
is what I'm saying.
No, I'm saying that the next homeowner down the street wouldn't say, oh, well, you lost your lawsuit, so I have to pay part of his share.
Well, that kind of brings up the issue exactly, and that exact scenario could happen. I'm not paying because a declaration was made by a court that says that the governing documents were invalid as they were ultimately put into place. Okay, under that circumstances, just like you said, Your Honor, I'm not going to pay. I'm not going to pay. I'm not going to pay. So what does a homeowners association do in that regard? That's exactly why they have to be part of the suit. You're going to have multiplicity of lawsuits.
Back that up, and so, all right, let's assume we agree with you and we affirm the Court of Appeals here. The Kappemeyer say, well, we don't want to sue all our neighbors, so we're just going to non-suit, but we're not paying. We're not paying the extra portion that the HOA wants us to pay. So now the HOA has to decide, now what do we do? Let's enforce it. So you sue the Kapmeyers.
Right.
Why doesn't Rule 39 require you to sue all 700 homeowners, or at least all the other Bay Lot owners?
Because I would not be seeking a declaratory judgment. I would be seeking a breach of contract based on their breach of not paying under the governing documents, which is construed as a contract.
Okay, and so then in response to that breach of contract claim, they file a counterclaim for declaratory judgment that we don't have to pay it.
We're right back to where we are right now.
You say now they would
Yes,
have to
sir.
sue all 700.
We're right back. I don't, but that's what I believe the Declaratory Judgment Act says. Yes, I do.
Is this
Go
a situation where you might actually prefer an action brought under Rule 42 so that you would not be subject to inconsistent obligations?
Help me understand your.
A class action. I mean, would you be
Right.
complaining if the other side had managed to find some people, a canal owner, a bay owner, a handful of people from each of the units and asserted this as a class action?
It's a really interesting question that I went over with my partner yesterday in preparing for this argument. And The problem in that circumstance is when you get into class action and class status, it opens up such a litany of complexity that, frankly, I think is unnecessary because it's already addressed in the Declaratory Judgment Act. Please keep in mind, we're talking about homeowners associations that are governed by people that are volunteers serving their community. I know oftentimes we look at them like, for example, the Apple computer brought up the example brought up here today. It's not. This is simply a $300 a year assessment so roads can be fixed and maintained, parks can be maintained, and the pool can be maintained. And when you start talking about class action status, then you're really talking about, it's just frankly prohibitive when you're with a volunteer community association.
Isn't it prohibitive to have to sue 700 people for a $400 assessment too? Then?
With all due respect, when you have what is typically what we see, 1 out of 700 deciding that they don't want to follow the rules, no, Your Honor, with all due
What if
respect.
it was one of 7,000? There's a homeowners association in Florida that has 7,000 owners and 20,000 homeowners.
And I think under that circumstance, I think the court would have to consider that in the discretion that is given to them by the rule.
But what about the fundamental rights of property?
Again, it is up to each particular judge and each particular case.
Each judge can just, fritter away somebody's fundamental right to property interests.
Under that circumstance, I would have to know the facts, but if it was an outright, we don't want the governing documents to apply to the other 6,999, the answer would be yes.
That they could. So okay to fritter away somebody's fundamental rights to property if there's a lot of people whose rights are about
Oh, no, I said they
The
should
other
have to be brought in. Yeah,
Okay, so
be brought in.
700, maybe it's
I think
like
if,
a winning and losing.
it is a circumstance particular each case. In my personal opinion, if you're asking me, if you're going to seek a declaratory judgment that's going to impact the other 6,999, they should be brought in. Yes.
So what I've heard you say, I think, is that the key right that's at issue is to not have to pay the other people's share.
Well, that is a fundamental property right as set out by this very
But
court.
who would be
there's more
better
than
to
that.
represent that interest than the property owner association itself?
I'm sorry.
Who would be better situated to represent that? Why would each individual property owner be better situated to defend the right not to have to pay the Kappemeier's interest than the homeowners association that in theory exists for that exact reason, to make sure everybody's paying their
Because
share?
that is a right not owned by the homeowners association.
What is the homeowners association for exactly then, if not to represent them?
The homeowners association is there to guide, it's a nonprofit entity formed under the state of Texas that is there to essentially govern using the governing documents set out when someone moves into the community.
And
is
is
amended thereof.
representing all of these 700 owners, the board of directors, et cetera, is representing their interest by passing these laws?
Well, I think we're back to almost to the Apple situation. Yeah, is there a benefit when the homeowners association is an entity acting through its board, does certain things for the benefit of the community? Absolutely, that's its job. But it doesn't own the fundamental property rights of the owners.
And aren't we back to the Crawford situation too, where we said even if the person you're suing ends up having to come out of pocket twice for the royalties, which is certainly inconsistent, that's not enough if you don't claim, if there's nobody that's claiming an adverse interest. It seems like it's much worse for in that situation, the inconsistent obligations are even more glaring, and yet we said no joinder.
I think, again, Your Honor, with all due respect, I think it's a different, unique circumstance, and I just ask the court to look at the precedent that both trial judges, as well as, with all due respect, homeowners associations has followed, like in this case, as set forth in the Brooks versus Northglenn matter. File an abatement and get the joinder. If the court uses its discretion and finds it's appropriate, they're brought in. If not, then we go about our way. I see that I'm out of time.
Any other questions?
Thank you all.
Thank you,
Again,
Mr.
it's been a
Duncan.
sincere pleasure.
Mr. Sutton, I believe you have 5 minutes.
Thank you. I'll address a couple points here in rebuttal. It will be remembered that the president of this HOA at the hearing, when asked what the HOA does, she said, well, we're the representatives of all the homeowners. And when asked whether the HOA had any evidence that anyone claimed an interest, she said no. Mr. Godkin is correct. These are all volunteers, and they're actually in a case which this court denied review for a client of mine recently, the Myers versus Tahitian Village. There are 7,000 lots in Tahitian Village, and we brought that as a class action. And the reason we brought it as a class action is because of cases, some from this court, that say the class action is the ideal way to deal with widespread abuse in a subdivision by a homeowners association. Here's the thing. Filing a class action is not a mandatory thing. That's a choice that a plaintiff makes. And that is a momentous choice because it's an expensive and difficult road. That homeowner was not forced to file a class action, but it is a good vehicle if it's the right case and the right plaintiff.
Would it be here when the interests of the different owners of the property all seem potentially conflicting? How would a class, would you have to have a small class of just people who are canal owner or non-canal, I can't remember which one it is, but anyway, people who are a small set of the 700 essentially fighting all the others? Is that how it would work?
Yeah, it's a real problem in this case because, well, we don't actually know among the 700 people, who would have what views on things. The canal owners certainly have a different set of interests than the non-canal owners. So you might have to have some sort of a subclass. In Tahitian Village, we felt like we had everybody except the board on our side, so 6,993 people. In this case, I have no idea, and we would need class discovery really to understand more about what that class would be before we went into that motion for certification. That would be a difficult road in this case and expensive. The court was interested in this issue about whether someone's a plaintiff or the alignment of the parties, in essence. And one of the cases that gets talked about in this case is the Epernay case, which is extremely similar on the facts to this case. But in Epernay, one of the problems that the court identified, and that went our way, the homeowner did what we did, which is there were kind of broad claims about something being invalid, but the relief was only sought for the homeowner. The court said, the court did the Rule 39 analysis, but it also pointed out that the HOA itself had filed a counterclaim and yet did not join anyone. And I don't remember in that case exactly what the claim was and whether it would be something that would, quote, affect all the other homeowners. But it is another example where you have this procedural back and forth. As soon as a homeowner, whether it's a defense or a counterclaim, asserts something that could arguably affect everyone, or even if an HOA makes such a claim, under my opponent's rule, everybody in that subdivision has to be sued. And that's neither fair nor workable and constitutes a huge penalty in many cases. I want to say, elaborate or correct on something in our briefs. There are a number of cases that my opponent cites that we differentiate on the facts, like Dolly and Hartman. Also, there's a case out of Houston called Riddick against Quail Harbor, where it was a question of where the homeowner would win money because the homeowner's condo unit was damaged. And the court said, well, everybody's affected by that because all the owners would have to pay for it. April Sound Management is another case. The problem in all these cases is that those are the HOA cases occurring after the 1977 Clear Lake case, in which the court seems to think an HOA is something different than a corporation and does no Rule 39 analysis. And that's the problem with all their authorities. There's no Rule 39 analysis. I thank you for your time. If there are no more questions, I will sit.
Any other questions? Thank you, Mr. Sutton. Case is submitted. That concludes the arguments, and the case is set for this morning, and the marshal will adjourn the court.
All rise. Oyez, oyez, oyez. The Honorable, the Supreme Court of Texas now stands adjourned.